Richard, just before we kick off, I'm just going to make sure that we sent the there's amended stuff to the into the court to add to the bundle. I just want to make sure the judges got it.
Which amended stuff?
It was the amended index and the materials.
Oh, okay.
That's all.
Yeah.
It's the stuff in red that's in the amended index.
Oh, okay. Yeah,
All right.
I saw it come, but
Good morning, everyone.
Morning.
I'm sorry for the delay. We'll be starting shortly.
Thank you.
Thank you.
Yeah, I don't even have the amended index with Mark, but I don't particularly need it. I don't think.
Okay, I don't think there's.
It's the documents from last.
It was a document. Yeah, it was basically we just added in the documents from last time.
Right, yeah, no, that's fine.
Yeah, that's fine. So I just make sure she's got it. That's all. And it was added to her bundle.
Sure.
You both
Yeah, well, if
received
you
it.
want to check on that, that's fine.
Did they receive it?
You did get it though, right?
I believe I did see it come through.
Okay.
I received it.
Okay, thanks, Brian.
Shall I need to send it or send it now? What is it? What is it? Portal?
Morning, my lady.
Yes, good morning, everyone.
Good morning, my lady.
Yes, Gina, this is still a court proceeding, so you can read out the heading for me, please. Friday, the 24th day of September 2021, Court, Commercial Code 2 by Zoom at 9:46 a.m. before the Honorable Justice Tibber Williams, Civil Jurisdiction 2019, number 200, Terry and Thompson versus the Public Service Commission and others. Mark Deal for the applicant, Richard Horseman for the first respondent, G. Howard for the second and third respondents.
Mr. Myrie.
Mr. Myrie.
Yes, thank you. Thank you.
And while we're on the subject of corrections or additions, my lady, my learned friend, Mr. Adams, is just off to stage left.
He has not been forgotten. He's not seen, but he's heard.
He may well be heard. You never know, my lady.
Okay.
Just sorry, before my learned friend, Mr. Horseman, starts off,
Yes,
just very quickly, some housekeeping. Hopefully,
yes,
your ladyship has received the additional materials, and you have the index that is marked in red.
yes,
Thank you, my lady. Sorry, and I'll let my learned friend.
yes. Let me also just acknowledge that I appreciate the efforts to actually update my own hard copy files, but I did have them home with me. And so that wasn't possible. We've been working remotely for obvious reasons.
Yes.
Thank you, my lady.
And my lady, I sent through a couple sections, one of the public service regulations that my learned friend hadn't included in the bundle, and one section of the Senior Courts Act, which mirrors our Order 53-7. And I did provide one other case. You'll see, don't ask me to pronounce his name off the top of my head, but I don't intend to go into the case at all on the facts, really. It's just some of the comments made in the judgment, which is relative to the final issue that I'll discuss. So with that, my lady, I'm going to try and keep this as brief as possible. If I could take your ladyship to tab 7 of the hearing bundle, that's the affidavit of Carlita O'Brien. I just thought it's handy. I'm just to refer to, shall we say, this is the
Pleadings binder, yes,
yes, on the 2nd of July 18, where the PSC met.
yes,
And you recall my learned friend had indicated that they should have appointed her right then at that particular point based on the recommendation from the interview panel. So the only, just looking at page 30, my lady, in paragraph 5, I'm just wanting to address the decision that the Public Service Commission made on the 2nd of July. And you'll see Ms. O'Brien says the PSC deferred the decision and requested the acting permanent secretary meet with the PSC on the 2nd of July to discuss the recommendation. He attended the meeting on the 2nd of July. During the meeting, concerns were outlined regarding the applicant's managerial style. And the PSC decided the best way forward was to recommend the applicant act in the post for 6 months. During the time the challenges related to the managerial style could be assessed and successfully remedied. The PSC's decision was therefore to defer decision on the appointment with a view to reconsidering the matter in 6 months' time. And then, my lady, so just pausing there, and well, actually, if we could turn to the exhibit at page 1, and you can see the letter that's written back to the permanent secretary. You see it's at page 36 of the record.
yes,
So, and just picking it up on the third last paragraph, you see there was a discussion with Mr. Farrow, the PS. There were discussions about the managerial style, and they said as a result of those discussions, the commission felt that having her act for a period of 6 months would allow adequate time for the head of public service, Hawks, to ensure the acting permanent secretary assesses the challenges related to her managerial style and whether they can be successfully assessed. So the commission agreed to defer a decision on the appointment. So that was the decision, my lady. It was to defer the appointment at that particular time. And my learned friend who will come to the Constitution seems to say the only recommendation they could make was to the governor. And my lady, and as we pointed out, and I'll take you to the case of Gina Tucker, the PSC is free to regulate its own procedure. They were not satisfied at that time due to not just the matter of the previous feedback that they had, but discussions with Mr. Farrow about her managerial style. So it was entirely within their rights and within their power to say, we're not prepared to, at this particular point, appoint her. But what we do want to do is give her a chance and give her an opportunity. And so we're going to defer the decision. And what we'd like the PS or the ministry to do is to place her in an acting position and see whether these challenges can be remedied. There was nothing wrong with that. When my friend goes on the Constitution point, yes, of course, if they were going to appoint her to the substantive post, then of course the recommendation is made to the governor, and the governor 99 times out of 100 will of course act on that recommendation. But my submission
The decision to defer and the decision for her to act was made by whom?
Yeah, well, it was, you can see the letter. It says we feel that she should act for 6 months. It was a recommendation from the PSC to the head of civil service and to the permanent secretary. And if you look at the delegation of powers, that power is vested in Hobbs, which would allow him.
Where am I looking at for these delegation of powers?
That, my lady, well, we're going to come to it, but if we
Because
want to,
obviously the argument that you'll have to meet
yes,
is that whatever framework you source those delegation of powers from, it is not supreme to the constitutional provision that Mr. Deal referred me to.
well, that's what I don't understand his argument at all, my lady. The power to appoint substantially, if they were going to appoint her to the post right then and there.
Because it covers acting appointments as well.
Well, let's look at the acting appointments. Because the power, I'll just say this while we're on it, the power to appoint anybody to any post is vested in the head of civil service if the post is vacant and it's for a period not exceeding 6 months. It's written in black and white.
Where's that black and white?
In the delegation of power. It's towards the back of the, this is where I should have had his amendment. Yeah, they don't just get it.
By closing the pleadings binder?
No, hang on.
Okay.
Mark, where's the delegation of powers? In your binder. Sorry, it's in his authorities binder.
Okay, you're back on.
I expected that you were going to take me there and I was going to close the pleadings binder, but I'll keep it open.
14 and 15?
Tab 14 and 15, yeah.
Tab 14 and 15.
Yes.
So if you go to page 245, my lady.
Yes. I'm looking at 80. Am I looking in the Constitution? Because
No, I'm looking at the delegation of powers, public service delegation of powers regulations.
okay, and what page are you referring me to?
If you look at page 245,
245.
yeah. Perhaps we should back up to 243,
Okay.
to section 3.
Yeah.
The powers vested in the governor by section 82 of the Constitution in relation to the offices specified in column 1 of the schedule are delegated to the public officers specified in column 2 of the schedule. set out in column 3.
Sorry, just one moment, please. Yes.
So if you see section 3, the governor delegates the appointments. And I just paused there, my lady. You can't possibly think that the governor is going to make all the acting appointments that go on in the civil service. And so if you now go to page 245,
It's not all the acting appointments.
well, not all the acting appointments, but if you go to page 245,
Yes.
you will see any office,
Mhm.
right, head of the public service, so Hawks,
Yes,
power to make acting appointments,
yes,
and then the 4th column. So just pause there, and the power be exercised only if the post is vacant. So the post was vacant in this particular case. And if you look at B, the appointment shall not be for a period in excess of 6 months from the date when the appointment takes effect without the approval of the commission being the Public Service Commission.
yes.
And that's why I've never quite understood my learned friend's argument that somehow this recommendation, when the PSC said to the permanent secretary in Hawks, what we'd like you to do, head of civil service, is put her in an acting position for 6 months. The head of civil service is authorized to do that on his own. If it was 6 months and a day, then the Public Service Commission can authorize it, must be authorized. But in any event, they recommended that the head of civil service place her in an acting position for 6 months. The governor has delegated that power to the head of the civil service. And and if it's for 6 months, it does not require the Public Service Commission's consent. So this was a power exercised, and there was nothing unlawful about it or ultra vires about it. The head of civil service makes acting appointments where positions are vacant all the time.
Mhm.
This was a tool that this was a way that the Public Service Commission thought would be a good way to move the matter forward, to see if these managerial issues could be addressed.
And you would then turn to section 83 of the Constitution.
Yes. 83, yes,
Delegation of the governor's powers.
yes. The governor acting in accordance with the recommendation of the Public Service Commission made by regulations delegates the extent subject to the conditions as may be specified in the regulations. Which is exactly what I've just brought your attention to.
Yes, could my friend actually read the rest of it? Because that's the most important section.
As is counsel. Okay, so certainly, the powers vested in them by section 82, other than powers in relation to offices referred in subsections 2 and 4C thereof to the chairman of the commission or to such public officers as may be so specified. Yes. So I'm not sure what my friend's point is, because this is an acting appointment, lady. This is not, of course, they couldn't go ahead and point her to be the actual director. When you look at the delegation of powers, any office for acting, and this is the power to make acting appointments. Of course, my friend is right that they couldn't go on and appoint him to be the director without the governor. The governor has not delegated that power, but we're talking about an acting appointment. So I don't see how, I mean, if that was right, then the head of civil service could never appoint anybody to act in the head of department. And my friend seems to be nodding, saying that they can. Well, that's completely wrong. The head of civil service must be empowered to play. Let's just say something pops up, the office is vacant, let's just say for a medical emergency or anything. I mean, the head of service head of civil service is authorized to put in someone there up to 6 months on his own. That power is delegated. But coming back to, I'll say this, my lady. So even if that was the case, that doesn't mean that the Public Service Commission's decision, let's just say my friend was right.
Mhm.
That doesn't mean that the Public Service Commission had to appoint her on the day. They deferred the decision.
Mhm.
They're perfectly empowered to do that. So backing it up with the decision being to defer the decision, that has nothing to do with what my friend is trying to show.
I recall Mr. Deal's argument to be that that decision offended the principles of natural justice in that it was unfair and that
No.
they still had an obligation to operate fairly.
Well, that's a separate argument, my lady. I'm just talking, and we'll come to that. And my friend may have some traction later on down the line, but not at this particular point,
Mhm.
because my friend seems to suggest that if they were going to make this decision, that they needed to consult with her at that particular time, or if they were going to make some adverse decision against her at that time.
Mhm.
And the logic can easily show that can't be right. This is a exercise, my lady, in deciding who may be appointed to a post. If you were to follow that logically, every applicant who may apply for the job, they'd have to consult with and say, this is why you didn't get the post.
Mhm.
The applicant at this point has no idea what's happened. This is an internal assessment of who may be appointed to the post. So you don't consult with, they have the power to consult
Mhm.
with employees. They have power to interview them, they have power to give them tests. But that doesn't mean they have to, because they're going to make some decision that might affect how she takes up the position, that they have to consult with her at this time. And we'll look at that when it comes to looking at the McLaughlin case and the Allen case. Right? But if you could imagine, when the Public Service Commission is administering and appointing posts, you don't bring in every applicant, and when they're making decisions, in fact, they almost never do. So my point is this: the decision to defer the decision for 6 months was perfectly legitimate, was within their powers, and it's probably helpful to look again at my friend's authorities at the Gina Tucker case.
Yep.
It's just a couple of paragraphs there, which we will find at tab 3 of page 29.
Yes.
So we're looking at paragraph 56. And I'll just, if you could just read paragraph 56 to 58.
Yes.
So, and again over at 60, turn the page to paragraph 60.
Mhm.
The principle that a decision maker or tribunal is allowed to determine its own fair procedure in the absence of one prescribed by statute is long settled in case law. And the points that were made in paragraphs 56 to 58 is that they're entitled to make their own procedure. So I'm quite confident, my lady, that they're in saying this to you, that there was absolutely nothing wrong in the Public Service Commissions to defer the decision. They had genuine concerns, and might as well come to it now. Regulation 19.3 says they shall only appoint somebody if they think they're fit. They weren't satisfied at that particular time that she was fit for the post. And it wasn't just the single incident. You'll see there was a conversation with Farrow, who also raised, even though he felt the challenges could be overcome, also raised that there were issues with the staff and unions and the like. So This was,
Why weren't these things raised with her? Is it correct that the evidence shows that the various examples that were relied on were not communicated to her so that she could fairly partake in the operations and at least represent her own answer to whatever these examples were?
well, they were raised with it, my lady. I mean, but I think there's two stages. And if you go back to Ms. Carlita, Mr. Bryan's affidavit, because
Yes.
this is where the legitimate expectation comes in,
Okay.
when argument they rely on. And
Mhm.
so we're back to the exhibits, and we're looking at page 39 of the hearing bundle.
Yes.
But that's comes later in the time. We're actually going back to page 51.
51.
Yes.
Yes.
So looking at the bottom of the page, so this is after the PSC's meeting in July. The letters come out, and Mr. Lordy's is emailing Ms. Thompson, and you'll see, "Good day, Terry. Lynn. What I was told is after the 6-month period, the PCC will determine they were satisfied most of the issues have been addressed, but it's positive that appoint you to the post the probation period will follow. Also, asked to prepare a deep development plan tailored to you to address these points and make objectives and goals clear. We should meet with them when the plan is ready, go over it. I'm expecting the document to be within the next 2 weeks."
Did that happen?
There were discussions, and I think Mr. Farrow conveyed to her as well that the PSCs had concerns about the managerial stuff. They're going to put in this development plan. So this, and you also will see from the affidavit from Mr. Rochester, where the development plan specifically deals with, issues of managerial style and how you converse and deal with your fellow staff. So, but I mean, without getting myself, I think probably my friend's strongest point, or probably the point that the court might be live to in thinking about is after this was all conveyed to her, the development plan was put forward by Mr. Rochester, and then it was abruptly pulled back, which we'll come to, and I know my learned friend went to that. There's probably some scope to argument that before that should have happened, that the discussion should have been had with her at that particular time. But at this point, my lady, they have discussed with her. And it's important while we're on this.
My lady, sorry, with respect, my friend is I'm sorry to interrupt. My friend is misrepresenting the evidence. This is not a discussion between the PSC and Ms. Thompson. This is a discussion between various civil servants and Ms. Thompson. The PSC has got absolutely nothing to do with this.
My lady, I didn't interrupt my friend doing this.
I know. All right, I will keep my powder dry till.
My lady, the Public Service Commission doesn't talk with individual employees, right? I mean, they don't say, they didn't send this letter to Ms. Thompson. They discussed through the permanent secretary. So the permanent secretary is and it would have been Mr. Farrow ahead of time. But this is where, and I'd ask you to mark the page 52. The PSC will determine if they're satisfied if most of the issues have been addressed. If it's positive, and then appoint you. And this is after the 6-month period. So this was relayed to Ms. Thompson from the start. And I think Mr. Farrow's affidavit, when I'll come to a little bit later. But and when you look at, well, perhaps we should look at it now. Yes,
Yes.
yeah, if you're looking at page 140. And you see subsequent, I'm looking at paragraph 14, subsequently, I believe the PSC offered Ms. Thompson extended acting appointment. My acting appointment came to an end. Mr. Lordy was taking the lead on this. Mr. Lordy and I did meet with Ms. Thompson to discuss the offer period of development. And I recall we both offered support during the acting appointment. This would be a colleague of ours within the ministry that was moved to the tourism. So there was, you'll see there was a meeting, and where they conveyed, I mean, he doesn't go in any great detail as to what was discussed, but you will see the email from Mr. Lordy to Ms. Thompson is that what the PSC is going to do is we've asked is to have this development plan put in place. Now, if you go over to Mr. Rochester's affidavit, and if you look at the actual development plan, which actually, I believe it. I'll come to it when it's in my submissions, but just make a note of it. The development, it's not in his affidavit. It's
I
in
was gonna say, I don't think it's exhibited to his.
it's in Ms. Thompson's affidavit. As I come down my submissions, we're going to come to it, but I'll pick it up real quick. Just give me a bit. As I say, I've jumped right through my submissions. I believe it's in our third affidavit. Yeah. Yeah, if you go to page 62 and 63 of the hearing bundle.
Mhm. Yes.
So, yeah, if you look at page 62. And you'll see the development plan.
Yes.
And you'll see, just looking through interpersonal skills, treating others with courtesy, sensitivity, respect, consider, respond appropriately, behave in an honest, fair, ethical manner. Builds consensus through give and take, gains cooperation from others, managing conflicts, encourages creative tension, differences of opinions, anticipates and takes steps to prevent counterproductive confrontations, manages and resolves conflicts, disagreements, team building, inspire and foster team commitment. So, the thrust of what was discussed and the concerns of the Public Service Commission were discussed with Ms. Thompson. You know, this was the whole reason the entire development plan was being put in place. Because of the concerns, and I think, and then what we see what happens transpires next is the PSC receives a letter in September when Mr. Lordy said, this is not going to work. And we could just go to the minutes. I know my letter I popped the letter up, which hadn't made it to the record, but as I indicated to the court last time, if you could go to page 21 in the little correspondence bundle.
Yes.
Yeah, so these are the minutes from the September 2018 meeting.
Mhm.
And you'll see I'm sort of picking it up at the third paragraph down, over the following weeks.
Third party, yes, I see it.
Yeah, over the following weeks, many complaints were received from staff, BIU workers, official letter from the BPSU, copy to the Hawks. A meeting was held with the BPSU, BIU, as well as staff of Parks Department, more precisely the problems, Ms. Thompson's management skills, which would assist in development the training plan. Subsequently, no positive comments from the meetings were received regarding Ms. Thompson's past management practices. Mr. Lordy listed the following comments: exhibits unprofessional behavior towards staff in a manner which is disrespectful, aggressive, condescending, vindictive, talks down to staff, exhibiting bullying, discriminating, victimizing behavior towards employees, unwilling to listen to staff, talks derogatory about staff in the presence of others, not a team player, has a leadership management style, which is autocratic, dictatorial, no team spirit at all. Working environment is unpleasant as a result of the mistrust and confrontational atmosphere, which is not conducive to the productive professional operation of the parks. After listening to comments, Mr. Lordy requested union staff to give Ms. Thompson another chance to a new start, as everyone deserves a second chance. He reported the response was, she's had many chances in the past. She had no qualities to be in the position. So I don't need to go down to all of it, but if you turn the page, my lady, at page 22, Mr. Lordy offered the following recommendations. Number one, abort the current recruitment process. Continue with Stephen Tucker as acting director for a minimum period of 12 months. Lordy and Farrow agreed to meet with the commission to discuss the staff. The commission agreed to stand by its original recommendation for Ms. Thompson to act for a period of 6 months with a development plan. So even in the face of this, my lady, but this, my learned friend's case is that, and it's on the pleadings, that on the 18th September, they should have, the Public Service Commission, in the face of all this, had a duty to appoint her to the position. I mean, my submission is it would have been irrational and illogical in the face of all of that being reported back to the Public Service Commission to appoint her to the post. I mean, it's quite the converse. If they'd have gone ahead and said, no, forget the development plan, we're going to appoint her and put her in the post in the face of this. I mean, I couldn't conceive of a more irrational plan that one might, or decision one might make. But notwithstanding that, the Public Service Commission didn't give up the ship. They said, no, let's go back and try and keep this on track. And let's allow Ms. Thompson to run through this development plan. Okay. So in my respectful submission, nothing at all is wrong with that decision. How my friend could suggest that the Public Service Commission should have put her in the post at that particular time is mind-boggling. Then, as your ladyship will recall, then a new Mr. Randy Rochester comes on the scene as the new permanent secretary. At that time, he feels that he can make this work and go along with the recommendations. And we've just seen the development plan that he put to Ms. Thompson. And we should go back to, I mean, really it's for my learned friend, but and Mr. Myrie who would deal with it. But what he says, let's just go to it real quick. We're back in tab 8 of the hearing book. Sorry.
Yes.
The pleadings.
Are we going to Mr. Rochester's affidavit?
Yeah, yes. Sorry, that's Mr. Rochester's tab 18. Yes. Thank you, Melody. We're looking at page 144.
Yep.
And again, I don't want to steal Mr. Myrie's thunder, but as I'm here, over the coming weeks, I was approached by staff from the department who had expressed concerns consistent with the concerns mentioned that if Ms. Thompson were to be appointed, there would be a walkout of employees. Sometime in November 2018, I reached out to Ms. Thompson to schedule a meeting to provide her update. That meeting, maybe we should have backed up. Well, this is highlighting the concerns. This is after he sort of come on the scene. And at paragraph 8, sometime around the first week of November, I reached out to Ms. Thompson, scheduled a meeting, provide her an update. That meeting I recall advising her of the concern raised by staff, but at the time, I believed I could manage the staff by working with her during the 6-month period, which was to be a development period. And that's consistent with what was reported to the Public Service Commission. I'll take you to the letter from Mr. Rochester. However, I did not advise Mr. Thompson she would be appointed to the post, as it's simply not my decision to make, but I advised her I would make a recommendation after the acting period had concluded. And while we're here, my lady, we might as well, to save this from coming back, at this meeting, I advised Ms. Thompson not to share details of the meeting. It will only make it more difficult for me as the new permanent secretary, since the rank and file now progress these concerns to the respective trade unions. During the month of November, I met with union members, shop stewards, and trade unions on 2 occasions to discuss the possible appointment. Both meetings, I was vehemently reminded of the concerns about Ms. Thompson's leadership style and how the staff felt intimidated by her. I was reminded there would be consequences if she was appointed to the post, which in no certain terms meant a walk out of the staff of the department. It was a result of these concerns expressed by staff regarding Ms. Thompson being appointed that I determined that this was an obstacle I could not overcome. I was not about to expose the government of Bermuda to potential labor withdrawal. I recall communicating with Ms. Thompson to advise her of the concerns with the union, and as a result, the acting appointment would have to be withdrawn. This was an uphill battle I was simply not going to be able to overcome. She was never in the acting post when I came on board. My meetings were in the office of DENR, whatever that is. So now if we could go back to Ms. O'Brien's affidavit, and I just, and if you could go to page 37.
Yes.
And this is what was reported back to the PSC on the 23rd of November. You may recall the meeting, and that couldn't have been December 5th. It was November 5th with the Public Service Commission. I committed to meeting with respective trade unions regarding the possibility of having Ms. Thompson act as director for 6 months. It was my view from these discussions that
All right, 1 moment, Mr. Horstman, where are you reading from?
Sorry, page 37.
Yes.
You have a letter to Ms. O'Brien?
Yes.
Rochester? Sorry,
Yes. And what paragraph are you looking at?
you may recall, it's basically the,
Oh, I'm sorry. I was looking for the, okay, yes, I see it. Thank you.
Yeah. so I was just pointing out, this was, you recall at the meeting, he met with the PSC on
November 5th.
November 5th, the date's wrong there. So, and the second paragraph, it was my view from discussions that the approach was acceptable, that I could have the support of unions based on the plan to work Ms. Thompson through the challenges that were raised prior to my coming into ministry. Somehow this information has made its way into the rank and file. To that end, it's become increasingly apparent over the last week that bringing her on board in any capacity will be very contentious. I've been made to understand there's even a petition circulating amongst the Parks Department that has raised some 80 signatures in protest of Ms. Thompson acting. Therefore, I would like to withdraw the application for the post of director of the Department of Parks at this time until further notice. I've conferred with the head of public service, who has no objection to this course of action. Should the commission wish to discuss further, please feel free to let me know. So, as you can see the timeline related, in September 2018, the Public Service Commission had these had this report from Mr. Lordy's that just said this is never going to work for all the reasons he listed. And Mr. Rochester came on and said, I think I can make it work. And then a short while later, it's a matter of days, he said, I just can't make it work. And he withdrew the recommendation. My learned friend challenges this decision from the public service to accept the recommendation of the permanent secretary, withdraw the recommendation. And it's for that reason is why if you just look at
What precipitated Mr. Rochester's withdrawal over that period of days?
well, I think we just read through it in his affidavit that he just had, had discussions with staff, unions. There was a petition he heard was going on. I mean, you can see he set it out in the letter that he's had discussions. My approach was successful. It's become apparent that bringing on board will be very contentious. And that's something that I'm sure you can address with Mr. Myrie. But from the Public Service Commission's vantage point, they're sitting in a meeting and Mr. Rochester, the permanent secretary, has withdrawn the recommendation. Say, listen, we just can't make it work. The Public Service Commission had once tried to, I don't know if override's a good word, but it was slightly different with Mr. Lordy's. He was suggesting that the recruitment process be aborted, and the Public Service Commission was not in agreement to do that. In this case, in November of 2018 now, the permanent secretary is withdrawing the recommendation. And it's helpful. This is why I've sent the provisions in the public service regulations to you this morning that were not my learned friends binder. And it's just a short reference if you have them present or if you can look at the public service regulations. It's looking at section 10, subsection 2. And it's just that I can read it out. The head of the department in which the vacancy occurs shall review the applications resulting from the advertisement, shall make a report to the commission, state or not whether he is recommending an application for appointment, and if so, identifying the recommended applicant. And you'll see at the front page, I've highlighted the head of department means the permanent secretary. So it's the permanent secretary under the regulations who makes the recommendation to the Public Service Commission. Now the Public Service Commission is faced with the position where the permanent secretary has withdrawn that recommendation. And just for completeness sake, we could go to page 38 of the hearing bundle, which is the Public Service Commission's letter dated the 4th of December, 2018.
Yes.
At the meeting on Monday, 26 November 2018, the Public Service Commission noted your correspondence dated the 23rd November 2018 regarding the matter of recruitment to the post. The commission wishes to thank you for attending the meeting to discuss the matter. In addition, the commission agreed the recommendation from the former acting permanent secretary should be withdrawn. It was also agreed the recommendation for Ms. Thompson to act for 6 months to develop her for consideration for appointment to the post be withdrawn. Once the Public Service Commission acts on the recommendation from the permanent secretary, the permanent secretary withdrew that recommendation. At that point, the Public Service Commission felt it had no alternative but to accept that recommendation, particularly in light of everything that has gone on. So that's the factual nature of matters, my lady. And what I like to do is sort of address the legal, and I see I'm going on longer than I anticipated I would. But what I would say is this: there was no legitimate expectation, as my friend has couched it, that she would be appointed to the substantive post. It was never said to her, the post is yours. You're going to be appointed. What was said to her, and I'm sorry, what was said to Miss Thompson was, we're going to try and you're going to act, or we're going to try and see if we could overcome the challenges regarding your managerial style. I'm going to put you in an acting post, have assessments done, and see if it could be overcome. Unfortunately, it just didn't work out. But, and as I've said, I'm going to pick it up in paragraph 34 of my submissions. My lady is sort of saving from writing. And this is just dealing with some very basic law, that any representation be relied on must be a clear, unambiguous, devoid of relevant qualification. And I've cited the email that we looked at. So our point is this: there was no legitimate expectation that she would be appointed to the post.
Yeah.
And again, at paragraph 36, I referenced the projected post title in the development plan that was provided to her by the permanent secretary, Mr. Rochester. And again, in paragraph 37, again, would reference that email. I mean, the highest I think my friend could pitch his case, my lady, is that perhaps she had a legitimate expectation that she should have been given this opportunity for this development plan. But you know, if you look at it in the round where they were discussing with the applicant, we've got to try and address your managerial style. There's plans going to be put in place. Then all the negative feedback that is coming back, the decision was, was a reasonable one in the circumstances. And Mr. Rochester, and again, this is really more for my learned friend, but it appears that he had, as I said in my submissions, a wholesale mutiny on his hands, but he did discuss with her and consulted with her. But what's not clear is how much was discussed with her in advance of the post being withdrawn. But certainly she was alive to the issues that needed to be addressed, and they simply weren't able to address them. My lady, what I would say is this: I'm now on to the final part of my submission, which comes down to what would you do in a case like this? Because I could see there's some traction in my friend's argument that she should have been consulted before the post was pulled, although there is and I'll leave it for Mr. Myrie, but she wasn't operating in a vacuum, and she knew the challenges that had to be addressed. But what would flow from that if you were to find that she should have, that Ms. Thompson should have been consulted before the post was withdrawn or the recommendation was withdrawn? And my lady, as I've said in paragraph 41 of my submissions, this is a discretionary remedy. I think it's almost accepted by my learned friend that it would be possible for this court to issue some sort of mandamus or to appoint it to the post, and that would be completely wrong in law, because the PSC never even got to the stage of making that recommendation to the governor. And of course, we know it's the governor who has to actually appoint it to the post. The governor had no involvement in this matter whatsoever, because the recommendation never made it to his desk.
I think what's being sought is damages.
Well, and I understand that. I'm going to come to that, because as you can see in my submissions, this is not a case that even remotely comes within the ballpark of where you can award damages in this case. It's simply because the damages would have to be based on the assumption that not that she would have gotten the post, but that she wasn't consulted before the post withdrawn. And I think, I'm not going to read through the discretionary remedy, but let's just go straight to the damages. In order to save time, I'll refer you to my written submissions and ask you to consider on that. But if you go, let's kick it off at paragraph 48 of my submission.
Yep.
And if you could take out my binder.
Yes.
And if you could go to paragraph, I'm sorry, tab 5 of my binder, my lady.
Yes.
And this is dismiss with the heading, no right to damages for unlawful administration action as such. And paragraph 1905, a finding by a court that a public authority performing a public function has breached the ground of judicial review does not of itself provide a basis for entitlement common law to compensation, nor does careless performance of a statutory duty give rise to any cause of action, tort, or in the absence of common law duty of care, negligence, or right of action for breach of statutory duty. To recover damages, I'm going to ask you to highlight this, a recognized cause of damage, tort, must be pleaded and proved, such as negligence, tort, breach of duty, no statutory duty, misfeasance in public office, false imprisonment, trespass. So while in some cases it may be a necessary condition, it is never a sufficient one for award of damages that the act of commission was unlawful in the public law sense. And of course, our order 53 rule 7 makes that very clear, which is a procedural rule, but it follows the substantive law, as we'll see. And then tab, if we could go to tab 6, this is Halsbury's, which brings home the same point. On an application for judicial review, the court may award damages provided a claim for damage was included in the application. And if the matter had been brought by an ordinary claim, damages would be available. This provision is procedural in effect. It does not create any new substantial right to damages. Rather, it enables a claim for damages to be sought in an application for judicial review where a private law cause of action, such as negligence, false imprisonment, is made out against the public body. A claim for damages cannot be sought alone on an application for judicial review. It must be combined with the claim for another remedy, which that's just one of the prerogative remedies, injunction and declaration. To recover damages, a recognized cause of action must be pleaded and proved. It will often be appropriate with the court having determined the public law issues to transfer the issues relevant to private law liability to another court. And you'll see, and they refer to at footnote 1 the Senior Courts Act, which mirrors our order 5307. There's no damages, there's no cause of action in private law for failing to consult. And remember, this is not taking away someone's livelihood or job. This is saying, I didn't get the promotion. And in this case, she never had a legitimate expectation for the promotion. It was to participate in a development plan to see if then the Public Service Commission would consider.
Yep.
So there's no private cause of action. Oh, I didn't consult with you before I made this decision. And that's brought home, and if you flip the page to tab 7, my lady.
Okay, Mr. Osman, just one moment. Let me just, I'm just going to stand the matter down just for 1 minute.
Yes, could I have a 2-minute refreshment break?
Yes,
Thank
thank you. You can come back at 10:45, just 5 minutes.
Thank you, lady. Yes.
Yes.
Yes, my lady. My lady, if I could take you to the case of Kassoon at tab 6 of my authorities. Sorry, tab
Yes.
7.
Tab 7, I think is where you have.
Yes, tab 7.
Yeah.
We get your highlighter out. We can run through it fairly quick. And this is almost a carbon copy of the case we have before your ladyship.
Okay.
If you look at paragraph 3, in March 2001, the appellant applied for promotion to the office of Commissioner of State. And in that year, he's invited to a promotion interview. It was interviewed along with other applicants. The interviews of the appellant and the other applicants were conducted by the selection board of the Service Commission's department. The service board forwarded its report on the interviews to the second respondent, the Public Service Commission. The report recommended the appellant and other officer, Mrs.
Sorry, give me a little background to this decision. This is a decision from
This is from the Court of Appeal.
where? Mega?
No, I want to say,
Where is this?
if you go to tab 8, it's from the Trinidad and Tobago, because we're going to come to the Privy Council
Oh,
decision.
I see. Okay, thank you.
This is the decision at first instance.
Okay, thank you.
And in a nutshell, he applied for promotion. He was the #1 applicant. And what happened? The Prime Minister vetoed the appointment. You can see just following on in paragraph 3, ending the last sentence, the commission accepted the report of the selection board, established the order of merit list. The appellant was #1 on the list, and Ms. Elder Alexander was #2. And what happened is, if you go to paragraph 15, my lady, a couple pages over.
Yes.
Pursuant to leave granted by Justice Noreen, the appellant applied for judicial review of the decision of the Prime Minister to object to or veto the recommendation of the commission that he be appointed to the office of consul, and the refusal of the commission to provide copies of the documents requested by him. With respect to the decision of the Prime Minister, the appellant sought several heads of relief, which essentially comprised an order of certiorari and declarations. He was treated illegally, contrary to the rules of natural justice. The Prime Minister acted illegally, unreasonably, unfairly, in refusing to endorse the recommendation of the appellant by the Commission for the promotion to the office of consul. With respect to the decision of the Commission regarding, well, that's not relevant. Go down to 16. The grounds on which the appellant relied on in challenge to the decision of the Prime Minister were identified in the statement of the appellant filed pursuant to Order 53 of the Rules Supreme Court. The decision breached the principles of natural justice. The decision was arbitrary, unreasonable, irregular, improper exercise, discretion, amounted to abuse of process. Looking down at F, that it was so unreasonable, no reasonable Prime Minister would have executed the power, would have so exercised the power. The Prime Minister took into account irrelevant considerations, or failed to take into account relevant considerations. So what you have, my lady, is this Mr. Kassoon was successful in the interview process, the #1 applicant, but the Prime Minister failed to consult with him, but vetoed it. And the court said, if you go to paragraph 20,
Yes.
21, there was no proper consultation within the meaning of section 1213 of the Constitution. The section was argued cannot be properly worked by a simple exchange of letters as occurred in this case. There must be exchange of views. And down at 4, the appellant was denied natural justice. He was entitled to a hearing before the Prime Minister exercised the constitutional veto. And what the court, the long and short of it, was, and perhaps go to paragraph 39, my lady.
Yes.
In making administrative decisions affecting rights, interests, and legitimate expectations, there's a common law to do the act fairly. This formulation of rights or interests are to be understood as referring only to a legal right or interest, but any interest deserving of protection, such as status, preservation, livelihood, and reputation. And what happened was, my lady, is the Court of Appeal agreed that the applicant should have been consulted in this particular case before the Prime Minister just vetoed the promotion. So if you come to paragraph 56, the last page of the case,
Yes.
which comes to the relief. So far as the relief that ought to be granted to the appellant is concerned, counsel for the appellant indicated he is not at this stage pursuing an order of certiorari in view of the time that has elapsed since the exercise of the veto, the appointment of Ms. Elder Alexander in the proximity to retirement of the appellant. He indicated that the appellant be satisfied with the declaration that the decision was made contrary to the rules of natural justice and the order as to damages. In my judgment, the appellant is entitled to a declaration. I'm prepared to make a declaration that the Prime Minister acted contrary to the rules of natural justice by making a decision to object to the appellant's promotion without informing him of the factors that militate against him and afford him the opportunity to make representations in his favor. On the question of damages, however, there is no claim for damages as required by Section 8(4) of the Judicial Review Act, and therefore I decline to make an order as to damages. We can flip over to see that they don't set out the section there, but it's identical to our Order 53, Rule 7. And this, the next case is the Privy Council case where it goes on appeal to the Privy Council. And for our purposes, to cut to the long and short of it, if you go to page 16 and paragraph 49, do you have it?
1 second.
Yes.
Yes.
So in this case, basically the Privy Council upheld it, but they tweaked the final order. In the result, their board would dismiss the Prime Minister's appeal in this case, save only to the extent buried the declaration granted by the Court of Appeal. In the circumstance of this case, the respondent was treated unfairly by the Prime Minister's failure to exercise his power of veto rationally, or at least to provide a rational explanation for exercising it against the respondent's appointment. Now, Mr. Kissoon cross-appealed on the issue of damages. And as for Mr. Kissoon's appeal against the Court of Appeal's refusal of further relief respectively against the Prime Minister and the Public Service Commission, these too must be dismissed. These arguments can be disposed of very briefly indeed. The claim for damages against the Prime Minister failed below on the ground there is no claim for damages as required by 8(4) of the Judicial Review Act. Section 8(4) does indeed provide, and this is a mirror image of our section, the court may award damages if the applicant has included in his application a claim for damages arising from any matter to which the application relates. And the court is satisfied if the claim had been made in an action begun by the applicant at the time of the application, at the time of making the application, the applicant could have been awarded damages. Mr. Kissoon's insurmountable difficulty in this regard is that claim for damages was and could only be based on his allegation that he was unequally treated, a claim pursuant to Section 4D and 14 of the Constitution. The allegation was struck out by the unappealed order of the trial judge. No claim for damages survived. And that would have been basically tantamount to a discrimination suit that he was treated unequally. But for failing to consult or for an irrational decision or being treated unfairly by the Prime Minister and vetoing the promotion, there is no damages that could be awarded to the complainant. And that is because, my lady, you have to have a private law claim in damages before any damages can be awarded. And this is why we say this case has always been pitched on Ms. Thompson would like a nice hefty award of damages, saying that she would have received this promotion and all this additional salary that would have come to her. One could imagine that if in every case where someone failed to consult with an applicant and damages were awarded, the government would be broke. it's not a private law claim. Of course, there is the public law relief. And as in this case, a declaration was made that was treated unfairly. Of course, they got their costs. And this comes back, and I should have, I skipped over the discretionary remedy. We're 3 years down the road now, my lady. It certainly must be unworkable. And I think Mr. Deal accepted that in his submission, that one, like I said, this court should not and could not appoint you to the post. The best they could do is send it all back to go back through this process all over again. At the height, if we went down in flames on everything, the most this court could do is make a declaration that she should have been consulted before this decision was made against her. And of course, costs may follow depending on submissions that may follow there. And on the last case, my lady, that I sent you this morning, it's just helpful because this is the English Court of Appeal case. And the facts aren't terribly relevant to it. This is the case of Tenji's and another versus the Director of Serious Fraud Office. And this case had to do with where search warrants were set aside and there was a claim for damages for trespass. And in fact, the judge at the first instance referred the case for damages to be assigned to another judge because the court found that the search warrants were unlawful. But it's helpful if you go to page 4 of the case. Do you have it in front of you?
I do.
Yeah, you'll see where, in order to speed things along, I highlighted the passages I rely on in paragraph 7. And you'll see this is the section 31.4, which again mirrors our order 53 rule 7. And you can see the court's comments. This provision is procedural in its effect, and it is common ground, does not change the general rule of substantive law. There is no right to damages for unlawful administrative action of itself. The claimant must identify a tortious liability or a right to restitution recovery of a sum due. And again, if you turn over to page 5, they cite dismiss, which I've already taken you to, but again, they cite it instead of finding that a court performing the public function has breached the ground of judicial review does not itself provide a basis for entitlement common law to compensation. To recover damages, a recognized cause of action must be pleaded and proved. So the last thing I would address you on, my lady, is the case of Laughlin that my friend relies on.
Yes.
And I'll simply say this, is that, well, we should look at it real quick, just the last part of it. But before we get to it, let's see, what is that? I believe it's at tab. Yeah, it's tab 20, my lady, my learned friends authorities. And one can see why damages flowed from this case. Because Mr. McLaughlin had his post and he was unlawfully removed from the post, which was said to be, that decision was said to have had no effect at all, which means he was in fact still remained in his post, but he hadn't been paid during that period. So there's a big difference, although the court said, the Privy Council said in that case, it's not the same as wrongful dismissal, and you're just not entitled to reasonable notice. But here you have someone that's employed, that a decision's been made to remove him, that's been deemed void or unlawful. And so if you look at the last page at paragraph 18,
Yes.
Yeah, I mean, if you go to the last paragraph, actually, Laughlin's PO must be allowed and the Court of Appeals order set aside. The board declares that the purported dismissal of Dr. McLaughlin as of 31 December 1998 was ineffective in law to determine his tenure of office. That Dr. McLaughlin is entitled to recover arrears of salary from 1 April 1999 to the payment of pension contributions on his behalf, make allowance for his earnings in the United States until he resigns or his tenure of office lawfully comes to an end. So what they found is he's still employed. He hasn't been, the decision to terminate his employment has been, was void or unlawful, was of no effect. So that's a big decision, but my friend tries to make the quantum leap and say, well, using that analogy, my client, would have been promoted, and there's no, as I've been in pains to say, there was no guarantee that any of this would have worked out. But the highest their case is that she wasn't consulted, and that does not, it's not a private law cause of action. So there are no damages that could possibly be awarded in this particular case. And on that basis, my lady, we say the Public Service Commission, when the Public Permanent Secretary withdrew the recommendation, that's who they take recommendations from and consider. They had to accept the recommendation. If your ladyship found she should have been consulted before that, then a declaration would follow, much like in the Kassoon case, which we make submissions on cost later. But there could be no question it would be a grave error of law if this court decided that based on a failure to consult or whatever their case, the other limbs of their case, that Ms. Thompson be entitled for damages moving forward on the basis she would have been the director of planning. Parks. So those are my submissions, my lady, unless I can be of any further assistance.
Thank you very much, Mr. Horstman.
Thank you, my lady.
Mr. Murray?
Yes, my lady, good morning. Also good afternoon. Oh no, still morning.
Still
I adopt Mr. Horstman's arguments in relation to the government. I think I just wanted to clear up a couple of, I think, maybe more factual submissions by the applicant. So one of them was dealing with the fact that they mentioned in a lot of the grounds that she was acting for nearly a number of years, and that alone amounts to she should have been appointed. So she was an employee, as you know, and if you turn to the pleadings binder.
Yes. For my desk.
And if we go to tab 19.
Yes.
Which is the affidavit of Mr. Craig Burt. I'm actually going to be going to the exhibits. So they've, MDM had it marked as page 184. So these were the original general orders that would have been in existence at the time Ms. Terry Lynn Thompson actually signed her employment contract.
I see. What page does it start on?
It's at tab 19. Let me see.
No, I see 167. No,
Yeah, 167 is when it starts,
okay.
and then
All right. And you're taking me
184.
to 184.
Correct.
All right.
And it's actually paragraph 318.
Yes.
And I read it. A person engaged in a temporary capacity as defined in orders 315 and 316 shall not be considered to be appointed to a public service office under the provisions contained in these orders as they relate to such appointments. So that's at the time when she signed.
Mhm.
And if I can take you further, so of course, these orders, these codes, I think it's the Employment Code of Conduct, have been updated.
Yes.
And if I can take you to page 297,
Yes.
it makes it even clearer. So this will be 3.8.2.
Mhm.
And then L,
Highlighted for me, yes.
yes. Any act and appointment does not imply a right to be appointed to that post at a later date.
Thank you.
And as Mr. Horseman has made abundantly clear, we are talking about an potential acting position, not a substantial position. And so this goes to the point as well to legitimate expectation. She could not have formed legitimate expectation when her contract says very different.
Yes.
So that's the first point I wanted to make. My lady asked, well, before I get to that, Mr. Horseman also made it clear that the applicant could only have received information in regards to what was actually offered to her.
Mhm.
Now, in the grounds of submission, which is in the pleadings binder, tab 1,
Yes.
at page 6,
Mhm. Yes.
this is if you look at number, or the little 12,
Yes.
XX11,
Is
it says on,
12?
oh,
Roman-
22, I'm sorry, that's 22, I'm sorry.
Okay, yes.
Sorry, yeah. On November 5th, 2018,
Mhm.
the applicant receives an email request from Mr. Randy Rochester to meet that day. At this meeting, the applicant was again told of the PSC's recommendation to have her act for 6 months. And if she successfully completed the plan, she'd be appointed to the post at the conclusion of this sequence of events. So the applicant knew that she was only going to be appointed potentially for 6 months. And on successful completion of the plan, it would lead to a probationary period. She knew that. That's in her own grounds of appeal, or grounds.
Yes.
And Mr. Horseman has already taken you to, I'm not going to go there again, but he's already taken you to the affidavits of PS Farrow and PS Rochester,
Yes.
where neither of them promised the applicant any role. They couldn't, they didn't have the authority to, and they told her that. So with this, the applicant knew what the most that she could be getting was 6 months acting subject to a development plan. She knew that.
Mhm.
So anything more than that, which she could be claiming for, is beyond us, quite frankly. And so I just wanted to make those points clear. But again, I adopt what Mr. Horseman said. He's gone through the cases. I was going to mention the case of Gina Tucker. He's already done that. So I'm not going to repeat that. So, so those are my submissions. If you've got anything further to add, I'm happy to assist.
No, thank you very much. That was concise and clear. Thank you. Mr. Deal.
I'm sorry, milady. I was fumbling around to get back online, as it were. Thank you very much, milady. I hopefully will be. I doubt I could be as brief as my learned friend Mr. Myra, but I will do my best. A few points that I need to, I think, clarify, because rather than me taking the objections, as I said to my learned friend Mr. Horseman when I made one objection, was I will keep my powder dry. And there has been, unfortunately, a number of misstatements of our case. And perhaps we can summarize it in this way, milady. If I can ask your ladyship to turn back to, my friend Mr. Horseman took you to the letter of it's in Miss O'Brien's affidavit, that's tab 7.
Yes.
And the letter is, I think it's the first letter. Yes, sorry, it's the letter dated, yes, it's page 36, my lady. Sorry, I didn't make a note on mine. This is the letter where that follows the initial, just to try and put it in context, the initial meeting of the Public Service Commission, where they had invited Mr. Farrow to come along and speak to them. Where Mr. Farrow, and you recall his evidence, said he thought there were challenges that she could overcome. And then they make this decision. And the decision is, as set out in the last paragraph of that letter, that there would be an acting position. Okay, so it agreed to defer a decision on the appointment of the post of director until she completes this 6-month acting period. So they came to that, quote, decision. Now, they did so, my lady, as we now know, without the opportunity of my client to make any representations to the Public Service Commission at all. They also did so in spite of Mr. Farrow's statements to them, and in spite of the unanimous recommendation of the interview panel, of which, by the way, Mr. Rochester was a member of the interview panel. So they came to this conclusion, or this decision, solely based on what I would call insider information. You remember Mr. Farrow's affidavit, milady, where he actually said quite candidly, I don't know what they were, I don't know what their concerns were. I'm paraphrasing, but your ladyship, I could take your ladyship to it, but
No,
I think you probably remember that, yes. So that was the beginning of this whole mess. Now, as I've said already, we already know that there was no consultation made. And in fact, my lady, my learned friend, Mr. Horseman, in his submissions, made a very stunning statement where he said, quote, "The Public Service Commission doesn't talk with individual employees."
He says they communicate through permanent secretaries.
Well, yes, my lady. So if you will go to paragraph 10 of my learned friend submissions, for ease of reference, you will see he sets out helpfully there the extract, thank you, the extract from Regulation 14.
Yes.
The Commission may require information and may require any applicant to, and I'll look at B just for ease, attend for such interview, examination, and tests as in the opinion of the Commission are necessary. So they didn't avail themselves of this ability. More importantly, they breached the rules of natural justice. And we know that. in not giving her this opportunity. We also know that, your ladyship, and I can take your ladyship to, for your ladyship's note, it's page 39.
Page 39, yeah.
Yes, I took your ladyship to it earlier, but I'd ask your ladyship to review it again. It's Miss Thompson's email, where basically she's saying, I don't know why this position was withdrawn. And she says, and she actually says, and it was not clear how this outcome was any fault of mine.
Yep.
So anyway, we know there was the breach of rules of natural justice. Then the issue was compounded because my friend Mr. Horseman in particular says he didn't understand our point on that. It was compounded by the fact that they then communicated with the head of the civil service. If your ladyship goes to, if your ladyship goes to tab 13 of the authorities bundle, very quickly, and look at section 3. That specifically refers to the power of delegation under section 82 of the Constitution. Then if you go on to
Yes.
tab 15, page 249,
Yes.
there is paragraph 82, the section 82 of the Constitution,
Mhm.
and we're looking at subsection 2, which we've seen. Yes?
Yes, yes.
I'm sorry, I'm just doing this very quickly, my lady. And then if your ladyship goes, I'm sorry, unfortunately, back to tab 14,
Yes.
then you will see under section 83(1),
Yes.
the one thing the governor can't delegate, one thing he can't delegate is his powers under subsections 2 of section 82, and that is absolute. It doesn't have, as my learned friend, either of my learned friends would like, a little provision with brackets in 82 saying you can't delegate, except acting appointments. It is absolute. You cannot delegate any appointments in relation to any head of department. Period.
Why do you say that that includes acting appointments?
Well, it must do, my lady. If it's an acting appointment, it's an acting appointment in relation to that head of department. It's an appointment of that head of department. It doesn't say permanent, and it would have to. It is an absolute ban on any delegation of any authority to appoint a head of department and carries with it the obligation to consult with the Premier. Now, that wasn't done. And in fact, it's rather interesting, curious, because this point was only made in submissions, in oral submissions by my learned friend, Mr. Horseman. And I think I need to take your ladyship to our pleadings, because we canvassed this point in our amended pleadings, tab 15 of the
Sorry, just one moment.
Sorry, Millie.
I'm
Yes.
stuck on.
certainly on the acting issue.
Yeah, so you say then that the public service regulations
Delegation of power.
3, yeah, the delegation of powers
Yes.
is unconstitutional.
No, milady, no, I'm not going that far because I don't need to. What you have to do, or what any court has to do, sorry, I don't mean to teach your ladyship to suck eggs, but you have to construe any legislation so that it is
read
consistent.
as if it's in conformance with the Constitution.
The lady has the point. So I'm not saying that in this case, because this case is unconstitutional, you strike out the whole section. That would be wrong. I am simply saying that in this, because let's go back to the section 3. Sorry, I moved away from it. So section 3 says you can delegate we're delegating all the powers in relation to the offices specified in column 1 of the schedule. So if you then turn to column 1 of the schedule, my lady, you'll see there's lots of examples which are not we would accept, are not, certainly as far as our case is concerned, not conflicting with that issue. But where we're looking at, the one we're looking at,
Number 8.
8A, at page 245,
Yeah.
that is. Because like it or not, and we'll come on to this point, like it or not, the director of parks is the head of the department.
Not the permanent secretary.
Well, I'll come to that point because that was a point, and I was just coming on to that point because we had raised this in our pleadings considerable time ago. No issue was taken with it, but so your ladyship goes to tab 15. Where's the? Oh yes, tab 15, page 126, my lady. This is our amended notice application for judicial review. Where we set out the argument. Now, did your ladyship see it at the bottom of the page? Roman
I'm in
numeral
tab 15 and I'm looking at
126, my lady.
one.
Oh, sorry, 16, my lady. Sorry.
Okay.
Thank you. I'm obliged, my friend. 16. Sorry, page 126.
Yes. Thank
And
you.
I'm looking at Roman numeral 18, bottom of the
Yes.
page.
Yeah.
This is where we set out the point. By virtue of section 83(1) of the Constitution, there can be no delegation under that section of the governor's powers acting in accordance with the recommendation of the PSC in relation to the offices of permanent secretary or head of department. Further, such appointment under section 82(2) require consultation with the premier. We set it out very clearly there. And we say the director of parks is the head of the Department of Parks as its Patty statement shows. Now, we weren't asked to provide that because no issue was taken with it. But we have, so we're a bit surprised to see this morning the extract from my learned friend where he is now asserting, sorry, where is that? That one there, is it? Sorry, we've got bits of paper flying around. Yes, thank you. This extract sent by my learned friend on the Public Service Commission regulations,
Yes.
where he says heads of, and he made this submission, which was endorsed no less by the Attorney General. Head of department means the permanent secretary. He said in terms, the head of department is therefore the permanent secretary. My lady, we will send you the Patty request that is referred to. We have it here. It for ease of reference, my friends can obtain it off the internet. It's there. If you do a simple search for Patty Department of Parks, it comes up. And the lady, for your ladyship's note, at page 3 of the Patty document, so this is a government document, it states in terms that the director of parks is the head of the department. So it's stated at page 3, and it's stated at page 7 under the heading name and title of head. And at the time of this document, it was Miss Lisa Dawn Johnston, Director of Parks. So what is rather shocking, to say the least, is that neither the PSC nor the Attorney General's chambers, and that must mean the minister and the permanent secretary, even know who the head of the Department of Parks was. it is, as their own document states, the director. So there's no question. And that probably explains, my lady, why they thought they could just ignore consultation with the Premier, etc., under the argument my friend, presumably on instructions from the PSC, advanced this morning.
Mhm. Yes.
Now, on the issue of breach of natural justice, etc., my lady, can I ask your ladyship, because I'm going to try and kill two birds with one stone, hopefully, deal with the kissing, and paragraph 56. Yeah, kissing. It's the, yes, first, well, Court of Appeal decision. I've got it here. Yes. So, my lady, in fact, just to correct one minor thing, as your ladyship can see from there's two decisions. The first is actually not, as my friend said, it wasn't a first instance decision. The one is from, there's one from the Court of Appeal.
Yes.
And so if your ladyship has that.
1 minute. Let me just close out. Find this. All right,
Sorry, my lady. I know there's bits of paper all over the place.
that's fine. I'll sort through it.
Okay, so does your ladyship have the Court of Appeal decision in Kissing?
I know what you're trying to direct me to. I flagged it. I just don't see it.
My friend,
Oh, I see it. Yes.
yes. So in fact, I'm going to take you to the same passage my learned friend took you to.
Mhm.
And this is, well, I'll just read, unless my friend,
Wait a minute, this is not, oh, it was in his submissions, actually. That's where it was. Sorry.
yes,
It was a
yes,
misspelling.
I'm trying to deal with my friend's submissions and make the point at the same time on breach of natural justice at the
Okay.
same time.
So you're taking me to the Privy Council decision?
No,
or
my
the
lady,
Court
I'm
of
taking you
Appeal?
Court of Appeal first.
All right, yes, and then I have it, yes.
And if the very last page of that decision
Okay.
in Kissing.
Mhm.
So, my lady, can I pick it up halfway through paragraph 56
Yes,
and just preface it by saying that this is our case almost identically. He says, in my opinion, in my judgment, the
Mhm.
appellant is entitled to a declaration, and I'm prepared to make a declaration that the Prime Minister acted contrary to the rules of natural justice by making a decision and a decision to object to the appellant's promotion without informing him of the factors that militate against him
Mhm.
and affording him the opportunity to make representations in his favor.
Yes,
That is the first part of our case, almost identically. And that aspect was upheld by the Privy Council. And that is respectfully binding on your ladyship.
yes.
He then goes on to say, on the question of damages, however, there is no claim for damages as is required by Section 8(4) of the Judicial Review Act. Well, as your ladyship may remember, and I understand why my friend keeps using the word damages, perhaps no less because I use the word damages in our pleadings. But as I explained to your ladyship the last hearing, and I took
It's
full response.
compensatory, yeah, sorry.
It's consequential relief. It's, if I may put it
yes,
this way,
okay.
it's my legal shorthand, and perhaps almost definitely inelegant legal shorthand for consequential relief of the type as set out in, I always get McLaughlin. I always want to say McNaughton, and my criminal law days, thankfully, are long gone. McLaughlin. That is what we are after, Melanie. I'll come on to McLaughlin in a minute, but your ladyship will note firstly, and this was a decision in 2006 of the court. Sorry, it's 2009. 2009 of the court. The McLaughlin Privy Council decision came out in 2007.
Yes,
That case is not referred to in the Court of Appeal decision on consequential relief. So on that aspect, on the second aspect, the quote damages aspect, the court didn't even consider the McLaughlin issue. This point was not argued before the court. Quite simply, what happened in the Kissing case was that the damages claim was struck out at first instance. It was never appealed. So on appeal before the Court of Appeal, there was no proper appeal in relation to the quote damages aspect. And that point's made good. I see my friend shaking his head. That point is made good in the Privy Council, and I'll come to it. But in any event, milady, in any event, it doesn't consider the McLaughlin relief or type of relief. McLaughlin relief is not damages relief in the true sense. It is consequential relief upon an order being made or upon the court making an attempt to correct, as it were, a wrong. But I'll come on to McLaughlin shortly.
When you say that the Privy Council, they may not have dealt with it, but they certainly, or they may not have been seized of
Yes.
the issue of damages, but they certainly addressed it.
They certainly made some comments in relation to the issue of damages, my lady. Yes. Well, let's move on to the. I'm not trying to duck the issue. Let's go on to the Privy Council decision in Kissing, and you will note there too, because that.
Paragraph 50 is where I was.
Yes, I was. Well, I'm just going to ask your ladyship to note again. Obviously, it's 2011. Your ladyship will also, and you can take it from me, that McLaughlin is not dealt with by the Privy Council doesn't deal with its own issue of its own decision of McLaughlin in this case. So,
but is it saying anything that's inconsistent with the position taken in McLaughlin?
Yes, absolutely. But yes, but that's the whole point, because what they are dealing with in Kissing is solely the issue of damages. They are not dealing with consequential relief. And if we can go to paragraph 50, my lady. Yeah. Sorry, my lady, I just want to get my.
All right, let me just see if I can
Sure.
make sure that I am following you clearly. And to do that, I'm just going to look at the argument that was made by Mr. Horseman. In McLaughlin, the facts were such that Mr. McLaughlin was unlawfully removed from his post, and then he was not paid for a period of time while he was, as a matter of law, still occupying the post.
Let us, sorry, my lady, I don't mean to be picky, but the decision to remove him from his post in the McLaughlin case was ultra vires. So it was, sorry, I'm being a little picky because I think we should be clear on the terminology and what flows from that. So what the court held was in McLaughlin that because it was ultra vires, it was therefore void ab initio. Because it was void ab initio, it was as if he'd never been removed from the post. Yes? So in that sense.
Yes, as in I'm listening to you.
In that sense, the court was saying, right, on the issue of consequential relief, what is Mr. McLaughlin entitled to? Firstly, he's entitled to be paid for all the years in his case, that he hadn't been paid. Yes?
Yes.
And then, and importantly, in McLaughlin, he was then entitled to the benefits that he would have had, the benefits that he was entitled to going forward, even though he was no longer in that job. And we can go to that if it helps, my lady. If you can go to We can go to McLaughlin now if you like.
Yes, I have it open.
Oh, do, okay, I don't, sorry, so you bear with me.
Tab 20.
Thanks. We can go to the, whoops, mine just broke. We can go to the head note, my lady.
Because what he recovered were arrears in salary.
He recovered two, no,
And
he was entitled to two things. He was entitled firstly to the unpaid arrears of his salary
Mhm.
because of the fact that his termination was void ab initio. And then if your ladyship, I'll give up with this, or let's have to make a mess. And then if your ladyship goes over the page in the head note to page 277,
yes,
he was entitled to recover arrears, I'm just at the bottom of the page, top of the next page. So the plaintiff was entitled to recover arrears of salary and pension contributions since April until such time as he resigned or his tenure of office lawfully came to an end.
Mhm.
So that was his entitlement going forward. That is not a damages issue.
But he's in the
But-
position.
So-
He had these.
Yes, but my point is, my lady, that is not an issue of damages. That is an issue of the court looking at the situation to say what flows from our decision. That's what McLaughlin did.
Mhm.
They said, what is the consequences of our decision? What flows from it? It wasn't an issue of damages, because if it was an issue of damages, all he would have been entitled to was his arrears and his notice period for wrongful dismissal. And the court said, no, you are entitled to, pursuant to your contract, what you had before, and you are entitled to be treated going forward, even though you're no longer in that job. You have been working in that job for 7 years. You're entitled to get paid in that job as if you were in that job, doing that job, until you actually, quote, retire. That is the situation. We are, as I said last week, we are the sort of mirror image of the McLaughlin situation. We are looking at the situation to say, wait a minute, our client was wronged. Our client was deprived of a proper fair hearing. And what is the consequences of that on a balance of probabilities? Now, on a balance of probabilities, would our client have been appointed, or should our client have been appointed to that position? The answer is, in my respectful submission, unequivocally, no question. No question at all. Also, on a balance of probabilities.
So that's the
given
first finding that you invite this court to make.
that I invite this court to make. And then on a balance of probabilities is, would she have survived the probationary period? Again, on a balance of probabilities, given what you know now, the answer is equally yes, because she's acted in no fewer than 5 occasions as a director of other departments.
Is it appropriate for this court to make a finding of fact that she would have been granted the post?
On a balance of probabilities, yes, absolutely. You're firstly, in my respectful submission, should be finding that in accordance with the section on kissing at paragraph 56 that I read to you from the
Yes.
Court of Appeal decision. So that I would basically invite you to make that the similar declaration.
Mhm.
Then you, in my respectful submission, you should then say on consequential relief, what happens? Well, you should make a finding that on a balance of probabilities, she would have been appointed to that role. You can make an order, lady, and part of our application is that for an order mandate is requiring her to be appointed in that position. Now,
But you say I can still make a finding that she should have been.
yes,
appointed.
yes.
And so
Now-
then there's where your consequential, you say the consequential.
This is where consequential relief comes in. Now, because you can, this is a problem that the PSC and the Attorney General's chambers have painted themselves into a corner. Because what they've done is they have, through their own improper actions and improper findings, and I refer you to by way of example only, to my learned friend's last paragraph in his submissions, which I commented on quite strongly in the last hearing. They basically put themselves in a position by saying, you know, she's never going to get the job. And my friend basically said that today, said she shouldn't get the job. That, whose fault is that, to use, if I may use Ms. Thompson's own words? Whose fault is that? It's not her fault. The fault is purely the ministries, the permanent secretaries, and the PSCs. She had nothing to do with that decision. It's not her fault. So on that basis, assuming you make the order to say she should have been appointed, what flows from that? Again, this is McLaughlin principles. And then you can also go on, and that's my point. You can go on to find or to decide whether she would have made it through the probationary period. And there's nothing to indicate anywhere where she wouldn't. And as I say, no less than 5 occasions acting as a director in other departments. So the concept that she's not a fit and proper person is demonstrably wrong. So then what flows from that? Either she's going to get the post or she's not. If she's not, why shouldn't she have the difference in the benefits from her current position to her director position? Again, in line with what happened with McLaughlin, where he was basically, the Privy Council said, you're going to get paid going forward for doing nothing. You haven't been working in that role for 7 years. We are in no different situation when it is forensically examined. I accept, my lady, that it requires analysis to get there. But there's no, in my respectful submission, there's no question that one can make the procedural or consequential steps to get there, and there's ample evidence to do so.
Quantum leap analysis.
Well, my friend.
Sorry, Mark.
Oh, yes. And perhaps, my lady, I would ask, I'm not going to do it, but I will ask your ladyship, remind your ladyship on the last hearing, does your ladyship remember that I posed a number of questions?
Yes.
To your ladyship? I was grateful for your ladyship to carefully note them down.
Yes. I recall.
I would merely ask, I'm not going to go through them, but I'd merely ask your ladyship to go, I would encourage your ladyship to go back to those questions and see if my learned friends have answered any of them.
Mhm.
In fact, in my respectful submission, they didn't answer a single one. And at the very end of the day, it's a very simple question. Very simple question. After all of this piles of paper, documents and affidavits, very simple question is, was Mrs. Thompson treated fairly? And I think in his heart, in their heart of hearts, my learned friends would have to concede in those quiet moments that the answer must be no. I wonder how any of us would have felt having people making adverse findings about our character and personality without giving us the opportunity to say anything. And then, because they know no other way to deal with it, to pull the rug out from under her feet. The whole thing was just horribly, horribly wrong. My lady, can I just. Well, yes, Ed, sorry, I'm grateful to my friend. Again, my lady, I made mention of this at the last hearing, but if your ladyship is with us on the damages issue, as we said earlier, our suggestion would be to,
Well, you said that we should have a separate hearing.
my lady has the point, yes.
Okay.
Yeah, my lady, unless I can assist your ladyship any further, those are my submissions.
No, I want to thank council for their very helpful and thorough and concise at the same time submissions. I will no doubt be extremely aided by that. Obviously, I'm going to reserve. It is my hope and expectation that I will have a written decision within the standard 6-week period. But if for whatever reason it comes outside of that timeframe, you'll likely receive some notification from the registry as to when you can expect a decision. Okay.
Thank you, my
So
lady.
unless there's anything further, we can adjourn.
Thank you, my lady.
Thank you, my lady.
Thanks,
Thank
my
you.
lady.
And Mr. Horstman, happy birthday. I have.
Thank you, my lady. I'm off to Harborfront now.
Thank you.